Hello and welcome to a meeting of the California Paraprofessional Program Working Group Regulations Subcommittee. I will go ahead and take roll. Hartston?
Here.
Kirkmeyer?
Here.
Sarouche?
Here.
Okay, everybody is present. And I see that we have a number of people in the attendees group. Should we go ahead and call for public comment?
Sounds great.
If anyone of the attendees would like to make comment, please use the hand raise function in Zoom. I see one person so far. Do you want to set a time limit for that?
Sure. Why don't we go ahead and
Okay.
2 minutes.
Okay. I'm sorry, how long?
3 minutes, 2 minutes, 3
Okay.
minutes. We only have one.
Okay, sounds good. So we have Angela Grijalva.
Good afternoon, committee members. Thank you so much for allowing me this opportunity to speak. I wanted to make sure that y'all received one of my associates' input letter, Helen Bellamy, with the LDA contract and notice to consumer. I know, Amos, I love what you're doing and how you're trying to protect the consumer. I think instead of reinventing the wheel, and I hope this meets the protections you're looking to establish. But I think as LDAs, when we initially give our oral statement, I'm not an attorney, I can't give legal advice, I can't represent clients in court and whatnot. I think that provides an initial disclosure, if you will, notice, and then the notice to consumer then provides additional. So if it helps provide insight of what we're currently doing, that's just my little input, and I don't want to exceed any more time. Thank you.
Thank you. I don't see any other raised hands. Okay.
Okay.
So, Leah, did you, well, first, I was wondering, because we sent around the revisions to the rules based on some of the decisions made by the subcommittee last week. I was wondering if anyone had any comments on any of those proposed revisions. Doesn't appear they do.
They look good to me. I did have one quick, I guess, comment or question related to 1.5.1. So it is a little bit confusing, but I just want to make sure I understand.
Okay, you want me to, let me share my screen so everyone can see what we're talking about. Bring this over here. Okay. Okay, can everyone see?
So, and my question really is just to make sure everyone's on board that this is what we intend, and also to ask, or to think about it, how this tracks the ABA rule, because I think that's our intent. So in 1.5.1A2, there's an or, right? The division is in proportion to the legal services performed by each licensed paraprofessional, or each licensed paraprofessional assumes joint responsibility for the representation.
Mm-hmm.
And then I think that's consistent with what we discussed. Then in 1.5.1B2, there's only one option when it's shared with an attorney, which is the division is in proportion to the legal services performed. There's no other alternative that each assumes joint responsibility. And is that because we're just presuming if a lawyer is involved, it's going to go beyond the limited license?
Well, I think we're and this gets back to our discussion from last week. We're recognizing that it is a limited license, and therefore there may be circumstances in which a paraprofessional cannot assume joint responsibility for the matter, meaning that assume responsibility for all aspects of the matter. And my takeaway from last week was that the group had decided that we would only provide this one option when the fee sharing is between a paraprofessional and a lawyer to accommodate that.
The reason I raise this is I just want to make sure we are not putting any barriers to lawyers and paraprofessionals working together on a matter from the inception. So I think we're thinking there will be serial representation. So paraprofessional first might go beyond the license, and then you need to go get a lawyer. But I think we also want to accommodate lawyers and paraprofessionals working together from the beginning. Now that's easy if they're in the same firm, but this is the rule that would apply if they're at different firms. And I just want to make sure that we're thinking of that possibility.
And I think this rule would accommodate that situation.
Yeah, because, well, it would limit the paraprofessional to getting fees just based on their proportion of the work in
Right.
that circumstance, right?
Right, and making clear what the fee division is, what the shared responsibility, the responsibilities of each of the paraprofessional and the lawyer are. You know, all the terms need to be disclosed as well under the rules. So, yeah.
So Greg, just to make sure I understand, because I didn't catch this when I reviewed it earlier, why don't we have the exact same language in 2? So there can't be any joint responsibility for the representation.
Right, because there are situations in which they would not, the paraprofessional could not assume joint responsibility for the matter because certain tasks or even certain aspects of the matter go beyond their licensure. So right. Joint responsibility means if for some reason the lawyer is hit by a bus or something happens where only the paraprofessional now has responsibility for the matter, are we asking them to take responsibility for something that, for tasks that they are not licensed to perform? They just can't do that. There may be situations in which the entire matter fits within their scope of licensure, but I think we can still accommodate that situation by being clear that the division of the fee is in proportion to the services provided.
Okay, I got it.
Yeah, that works for me too. Thank you.
Mm-hmm.
This is Kim. I just want to be clear. So that won't stop them from being able to work together though, like Amos was talking about. So if that's the case, I'm good with it too.
No, it shouldn't stop them. And Randy and Andrew, feel free to jump in if you have any different view on that.
Well, just to be clear, it wouldn't stop them from working together, but it would limit the proportion of the fee the paraprofessional could.
Right. So the paraprofessional would not be getting any portion of the fee for work that they didn't do.
Or that goes beyond their license, right?
Mm-hmm.
We had extensive discussion about what the lawyer rule provides in terms of a pure referral. And the sense of the subcommittee was we didn't want that between paraprofessionals and lawyers. And we don't want that between paraprofessionals and paraprofessionals, but paraprofessionals and lawyers. But we do want them to work together. And so just as Greg was saying, an additional concern is raised between paraprofessional and lawyers where a paraprofessional under the ABA model rule should not be allowed to assume joint responsibilities for matters that they can't perform based on their limited license, just exactly as Greg said. So in order to permit them to pair up with lawyers, they can do that so long as they're doing the work that they're entitled to do and they're getting paid for the portion of the work that they're performing. But in order to quote unquote protect the public, and these rules could be revised in a few years depending on how the paraprofessional program develops and how lawyers and paraprofessionals begin to work together. But as an initial set of rules, as I recall the conversation yesterday, wanted to protect against paraprofessionals assuming responsibility for matters that the license just won't allow them to assume.
I'll suggest that this might. What's that?
I said, Andrew, when you say yesterday, you mean last week?
I meant last week. Yes, of course.
Nobody believes
they're all bleeding. They're all bleeding together.
I'll just suggest that this might be an appropriate place for a comment. I know we're going to try to be limited, but this fee stuff will be very important. to people, and it is somewhat confusing. So
Yeah, so I don't know if you
Absolutely.
see my comment here, but I said add comment that a paraprofessional can only assume joint responsibility for a matter if the entire matter is within their scope of licensure. Okay.
Totally.
And then I think with 1.5, we left open this idea of well, I think we decided that we do want a fee cap, but we left open the actual discussion of the cap. And I don't know, Leah, is that where you want to start today?
No, I think we should start with the big kahuna. Disclosures, informed consent.
Okay.
I did
So
mock up something that I sent to Linda that she could share if I leave, which I think it just starts to become playing around with different options and seeing what people are comfortable with.
Okay.
But I think we should start with the more meat.
Okay. Can you see the where it says for discussion purposes? Am I on my screen right now?
Yes.
Okay. So as the working group, the subcommittee members know, I sent around before the last meeting, before we decided to punt this to today, 3 rules, just so that we could have solely for discussion purposes, because we would, I think where we last left off was whether or not the informed consent and or mandatory disclosures that a paraprofessional must make to a client, a prospective client, what is the trigger point for that? Is this something that they need to obtain immediately at the first consultation with the paraprofessional? Or is it a informed consent to representation, which I think is Amos's position? In which case, I don't want to rehash our conversation around this. I think there's some concern, especially from members of the Office of Professional Competence, because informed written consent, informed consent are both defined terms. And we want to make sure that the way we use them in these rules is consistent with the definition, not only in these paraprofessional rules, but also the definition under the lawyer rules. And so I think the best way for us to really begin the discussion is to come to some consensus on whether or not there should be 2 or 3 rules. Because before we start talking about what the rules should say. And in my mind, I think really this decision hinges on 2 things. What are we asking the prospective client to consent to or to acknowledge if it's a mandatory disclosure situation? And whether or not, if it's to representation, then the trigger point is later in the potential relationship, up until the point in which a actual paraprofessional client relationship exists, and whether or not we really want to go that long before they make a series of mandatory disclosures to the client, such as I am not a lawyer. There may be other alternatives available to you, those types of things. So I just wanted to get feedback from the group on 2 rules or 3 rules. I think that's really the most helpful way for us to proceed.
So this is Kim. I'll start, and I apologize that my camera's not on. But I just wanted to say I've given this a lot of thought. I've looked at the language, and from my opinion, I think there should be 2. It's kind of like I'm going to say 2.5 actually. But rather than the 3 different ones. And I kind of drafted some language up, but my thought was that we would do the mandatory disclosure beforehand. And it's not that I put mandatory disclosure, but when I was looking at the language of it, it was really mandatory disclosure, but you're also discussing this with these individuals and providing them a document, a written document at that point. And that would be the first time it goes in your language, Greg, of prior to a prospective client's consultation with a licensed paraprofessional. That whole, the way you change that, the way we put that together. So it would be there, but it would also have to be that they also have to disclose it orally and discuss it with them, and they'd have to sign off on it. So So that would be the first disclosure that would come, and it's basically what we discussed previously, but then also added the cost sheet in there because of the discussion on costs. And I'm thinking, and this is kind of for a few of our professionals, they have to do a cost sheet. So if that could be something that would be provided, and then we would get rid of your 1.4.3. But then to Amos's concerns in the actual agreement, and I know this might be very different than like how attorneys do it, but you would have to give a written agreement to representation. But in that, you would also have to have, so into the 1.5.2 that we have, we would add basically a B. I know we don't have an A yet, but we'd add a B that something along the lines of, like, notwithstanding any other required informed consent, the written agreement shall also contain the client's informed written consent that they understand, and then we'd have what it is, that they, this individual is not an attorney, that they have other alternatives as well, and that this is the cost. All of that would be written out in the kind of like a written informed consent. So it's kind of like you would put that in with the written agreement. So that's kind of just my suggestion, to throw it out there to start discussion.
I'm just going to put this as a note right now, just so we can see what Kim is referring to. So this would become A, and then these would all move over to subparts. Okay.
Do you have, Greg, Kim sent us an edited version. I think this is before the last meeing.
Yeah, Kim, are you okay with me showing that?
Yeah, I am. It's
Okay.
it's not great. It's just some suggestions.
I gotta have
Yeah.
it right now. Okay.
Definitely needs work, but yeah.
Bump it up a little
I
bit.
think it needs to be bigger, Greg,
Yes,
for people
I'm
to
working on it.
see it. Okay.
I have a default to 2-page because I like to see more, but okay. So just to kind of rehash what I think Kim was referring to. So rule 1.4.2 would become mandatory disclosure prior to consultation with the prospective client. And then I think these are some of the other changes that she made. So it would not use the term informed written consent. You have a comment here, Kim. Limited scope services from a lawyer. I think we may have talked about this last time. There have been changes to rules of court, I guess many years back now, that allow lawyers to unbundle their services and limit the scope of their representation. And it was really an access to justice issue. I think Fariba has talked about that quite a bit at this point. And so this disclosure would just simply require the paraprofessional to explain, or at least provide a sheet that explains to the client that these types of limited scope representation services may be available from a lawyer if they choose to go that route.
Okay, that makes sense to me now. Yeah, I couldn't remember what that meant when I saw it in there, so that was the only question I had.
Okay, and then you're proposing not have this second rule for written consent to representation, but in the written agreement to representation, I think this is the B that you were talking about. This is your notwithstanding any other required for informed consent. I'll probably put an asterisk there. Within the rules of professional conduct, the written agreement under Section A shall contain the prospective client's informed written consent that they understand the licensed paraprofessional is not a lawyer, that the client may need a lawyer if needed services go beyond the scope of the licensed paraprofessional, and that there may be other alternatives available to the client.
Yeah, that was just my suggestion.
Mm-hmm. And then I think under this rule, you have a comment here also on the basis of compensation. Would it be unusual to put an estimate of the costs? I don't know if it would be unusual. The language that I used here is mirroring the business and profession code. I think it's 6147, the requirement for a written agreement that a lawyer must abide by if the contemplated legal services will exceed $1,000. So this is actually language just taken directly from the State Bar Act. But to the extent that we want to also include a obligation on the paraprofessional to include a cost estimate, not only the basis for how fees and costs will be calculated, but a cost estimate based on the scope of representation in the matter as contemplated at the beginning of the representation, we can certainly add that as well.
I think the reason oh, go ahead, sorry.
I was just going to say, I think that would be responsive to a lot of the concerns that were raised around in the fee cap discussion. So if there was a way to incorporate that into the rule, I think it would make sense to do that.
Right.
I was going to say the same thing, Leah.
I see you, and this was in, I think this is carried over from the version of the written agreement rule that Amos had originally suggested. This statement shall be clearly and conspicuously set forth in the contract. I think I had a comment that shouldn't we require all these statements to be set forth clearly and conspicuously since they're in the rule themselves, and you had removed that. So
I removed it. I'm sorry, Gray. I meant to put it like somewhere else. Like, yes,
Yeah.
I agree with you. It should be for everything, and I probably just didn't put it somewhere else.
Right. And under what is now 1, there is a clear and conspicuous disclosure that the licensed paraprofessional is not a lawyer and may only provide limited legal advice and services within the scope of their licensure. This statement shall be on the first page of the contract in a type, size, font, color, appearance, and location sufficiently noticeable. So we have, and you added boldface as well. So this is one area where we of all these specific disclosures that need to be within the written agreement, that we have requirement on how the text should appear. But I agree, even beyond that, all of these should be clearly and conspicuously stated as well. Is that that's the understanding that I'm getting? So we can add something up here that says the following provisions.
So for Reba or Amos, any thoughts on the 2 or 3 agreement question, 3 document question, or Kim's proposal?
So I'm having a little bit of trouble following. And I do think for me, the policy question is more important than how many rules or where the rules are, if we combine them into a single rule, or if there's 2 rules or 3 rules. But I think it's very clear from the policy perspective that coming into this discussion, we had two separate writings in 2 separate rules. And that is because the written agreement or retainer agreement is one rule, and there's a separate writing to confirm the informed consent. Now, I do understand that people have raised concerns about the informed consent language, but I did get a lot of comfort last time that was a semantic issue, that it's the defined term issue, and that there's no issue with the requirement that prospective clients need to be provided sufficient information to be able to make an informed choice of whether or not to hire a paraprofessional. So I prefer using the defined term language. I think it applies, but to the extent there's a concern with that language, I don't think that changes the policy choice, that there should be, an informed choice and a written agreement, and that the informed choice should be separately confirmed because that requires certain disclosures. So I think for me, the new item is the suggestion, I think by Greg and Kim, which I totally respect, that there needs to be some mandatory disclosures earlier. than the choice, than the written agreement or the informed consent, and that there should be some other maybe parallel disclosures. I think we're maybe a subset of the disclosures earlier. I think everyone agreed, and it's a little bit complicated, but everyone agreed, I think, that you can't have informed consent before there's any discussion. So at the very initial first conversation, first in-person meeting or first call, you can't have an informed consent requirement where there hasn't been a discussion of the facts and circumstances. And so I don't think we're talking about a different informed consent at the beginning. I think it's much more like the LDA rule, and that was helpful, by the way, the LDA sample contract and Business and Professions Code 6410, that is somewhat in that. There's sort of initial, I think it's called a notice to consumers, and that's separate from, you know, the written contract or that stuff. And so I certainly don't mind. I think it's a great addition and additional consumer protection if there's some initial disclosures, as I like to think about it, or, you know, consent up front. But I don't think that in any way takes the place that consumers need to be, you know what a paraprofessional can and can't do, and be able to make an informed choice when entering into the contract with information about the risks and alternatives. And again, I don't think there's any disagreement about that stuff. It's so I don't know. So it's a long-winded way to say, I don't know if it should be 3 rules and 3 writings. That seemed excessive to me, and that's not what I had in mind. But I absolutely, I'm not changing my position that the consumer, the prospective client needs to have information in order to make an informed choice to enter the representation. And that should be a separate writing than the written agreement. And I don't mind if the rules are combined, but I think, Greg, it was your suggestion earlier to separate them, to make that more clear. But I don't mind if we want to have fewer number of rules.
I think it's helpful to separate them, because if you think about how some of these relationships will develop, there may be situations in which the mandatory disclosures and the written agreement are entered into in the same meeting. But I can also imagine, you know, somebody going to see a paraprofessional, they're looking at different options, and they get these mandatory disclosures and information, including information about other reasonable alternatives to going to the paraprofessional, and they go explore those options and then ultimately decide, you know what, I really like that paraprofessional, I'm going to go back. And then they enter into this written agreement. So having them separated in rules makes it really underscores we are talking about 2 separate writings, and in many cases they might happen chronologically at 2 different times.
I agree with that. The only concern that raises for me is 3 rules sounds like a lot, and if it's 3 separate writings and it's very parallel to what's in the writings, it might seem repetitive or redundant.
Right.
I'd like to try to avoid that, but I certainly don't mind. I think it's clearer if it's separated, and that's I think what we had coming into this.
Right. Yeah, I wanted to put out the 3 writings just because the 3 separate rules, because just so we could just talk about it. I was certainly not advocating for 3 separate writings or 3 separate rules. And I think what Kim is suggesting is that we don't have 3 separate rules, that we take aspects of these written disclosures to representation and incorporate them into the written agreement to representation rule. And if Fariba, it'd be interesting to hear your feedback on this, on the 2 rules versus 3. And if we are in agreement, then I think we can start digging into the rules themselves and decide what should or should not be in there. And if there's any other aspects of some of the other examples that we've seen from the LDAs, as well as I think the family law facilitator disclosures has some interesting aspects in it that we might want to incorporate as well. But Fariba, what is your feedback on this?
Just to clarify, the 3 are having an initial disclosure, 2 having this informed choice or informed consent, and 3 a written agreement. Did I get that right?
Well, I think Kim's suggestion is that we not have 3 separate writings. Or
no, what you said. I want to know where you started with the 3. These are the 3.
Right.
Okay.
Yeah, for just discussion purposes,
Yeah.
we had talking about, hey, we need one writing. Some people were advocating for a writing prior to representation that is provided to a prospective client immediately when they sit down with a paraprofessional for the first time, so that they have that information. And then I think there was some discussion of that we also need to obtain in a separate writing their informed consent to the representation, and which also includes some mandatory disclosures, some of which need to be tailored based on the facts that the paraprofessional has gathered about the client and the matter. And then also another rule for the written agreement, which really makes, again, some of those overlapping disclosures, but also includes some information about the services that are going to be provided, the scope of the representation, the fees, how the fees are calculated, how costs are calculated, that kind of thing. And I think both Amos and Kim are now saying, no, we don't need 3 separate rules. We don't need 3 separate writings, perhaps. But what we do want to do is make sure that we have these disclosures at the outset of the relationship and have it captured in one rule, and then also impose a requirement that every representation by a paraprofessional needs to be consented to in writing by the prospective client, that has mandatory disclosures and these elements that are required for the written agreement.
So I think I agree with that. But let me just kind of explain. So, having read the child support, private child support collector rules more in depth than I did before, and kind of think there was a lot of abuses in this industry, and also immigration consultant, right? We talk about vulnerable clients, for these people parents who are trying to get their hands on some money, and these people were feeding off of that desperation, right? So you see all these detailed, it's so detailed. I kind of like 5612 that even says that within first 30 seconds of any phone conversation, certain disclosures have to be made. So to me, in what we're talking about here, I feel like in the very beginning, this early initial disclosure has got to have these really important points that we think every single client needs to know, and every single paraprofessional, without knowing any facts about the client's case, should be informing the client. And one big one, I'm not a lawyer, right? And we can decide on what else is important, just review what we've talked about. So I agree with that initial early disclosure. Keep it simple. What are the most important points we think from a consumer protection standpoint, we want the client to know. And then I think I like what Amos called is informed choice rather than informed consent, because I want to stay away from informed consent as well. So that, and putting it together, I thought I heard you say separate writing, but now you're telling me it's put together in the written agreement. Sorry, I misunderstood.
No, I'm sorry. I must have misled you. So these mandatory disclosures, the first thing you were talking about that happened immediately, that is a separate writing. And this is what I've attempted to capture under proposed rule 1.4.2.
Okay.
This second rule was the informed consent to representation. And this is based on Amos's original informed consent rule that we distributed in October. And Kim's proposal was, we don't need this and this is to representation, which means it implies that there has been some conversation with the prospective client. You've gathered information, you have a good sense of what their situation is, what type of legal services they need, and the scope of the matter. And now you're going to make some disclosures to them and obtain their informed consent to the representation. The concept of that, I think Kim has attempted to incorporate that in the written agreement to representation.
And I agree.
That's the separate writing. And so, and she tried to capture it under B, notwithstanding any other required informed consent within the rules of professional conduct. A written agreement under section A shall contain the prospective client's informed written consent that they understand the licensed paraprofessional is not an attorney, that they may need to seek an attorney if the services go beyond the scope, and there are other alternatives available. And I think Kim was doing this again for discussion purposes. This isn't final language,
Sure.
but I think what she was, and Kim, please correct me if I'm not characterizing right. You were trying to capture the concept of informed consent here that Amos had proposed originally within the written agreement requirement.
Yes, that's exactly right, Greg. Putting it into there to where it's kind of one document. They're doing all in that written agreement.
So that
Right.
was not my understanding. I'll go after you're done, Fariba.
Okay, that was my understanding. So I kind of like putting them together. But then when you and Amos were talking, I thought I heard you say separating. But anyway,
Right.
so, okay, I'm not crazy. Okay, so one question I have, I think we need to discuss more about the initial disclosure. You're talking separate writing. What if it's a remote conversation, whether it's by phone or by Zoom or whatever these days, how are we gonna do that? I kind of like, I thought at some point during one of the meetings, we talked about, the initial disclosure, when we started talking about the separate initial disclosure before any discussions had, that it could be, or we could have a rule. It could be just, orally inform the person, especially
Right.
these days. And then we talk about it specifically what, and I really want to go back and take a look when we're there to make it simple, and make it applicable to every single client regarding of the specifics of the case. Yeah.
I agree. And I think we should dig into it once we come to a consensus on 2 rules versus 3. It sounds like
Yes.
we've got a consensus on 2 rules, but I think Amos wants to
Yes.
clarify his position on that. And then I think once we have that consensus, then let's go look at the rule and say, what should be included in this rule, what shouldn't.
Okay. And one last comment is, are we trying to stay away from the term informed consent? Because it's defined as a thing?
Well, no, I don't think we should stay away from it. I think we should use it as it's defined. So to the extent that we want to impose an informed written consent requirement on a paraprofessional, we need to go back and look at that definition and say, is this something they can provide at this stage when this ethical obligation becomes active for them, right? So when someone walks through your door, you are not in a position to provide informed written consent within the scope of that definition, because you need to gather information from that person. And so in order to tailor the disclosures to their situation. And the concern had been, before they even gather information from them, we need to make some mandatory disclosures to the client to protect them, so that they know who they're talking to and what they're capable of doing and what alternatives may be available to them.
Okay.
Can I ask a question, Greg? Sorry, Fariba.
No problem. I'm done. Thank you.
Just to follow up on that, I thought what we heard from Andrew last time was informed consent in the attorney paradigm is used in reference to activities that would otherwise be excluded, unauthorized, right? I thought that was what Andrew said. And then I also want to add the recommendation coming forward from family law in June, as Fariba knows, it includes a specific informed consent component around cross-examination. I can't remember, it's expert, whether or not the paraprofessionals will be able to cross-examine experts. Maybe you remember, Linda, if it's in the DV case, there's a specific aspect.
I can pull that up if you hang on.
Yeah, there's a specific aspect which talks about the paraprofessional can only do this with the express consent of the client. So I just want to throw that in there, that I think we are going to have some aspect of this, of an informed consent concept as it actually relates to scope of practice and what would otherwise be excluded. If that
Okay.
And just to be clear, I don't think there's any problem using the defined term informed consent. And I believe that is what I mean and what was meant when we have discussed it before. But I do believe Andrew has raised a concern. But as I understand it, that concern isn't that doesn't have anything to do with the requirement that information and explanation be provided to allow them to make an informed decision. It's just about using the defined term. Is that right, Andrew?
Of course, absolutely. There are plenty of examples, and I think we've given them where disclosures are made and understanding is confirmed in writing by the client. So, of course, and and I understand that's an important public protection component for this group. And I think that that's the first rule of the two we've been talking about this afternoon. We contain those things, and that's totally normal and common in these type of engagements. And so that's not a problem. The problem I had was Greg said it more articulately than I did, which is that it's a defined term. And if we use it in a manner in these rules that departs from its application in the lawyer rules, and that's the world I'm steeped in, I'm worried that there's going to be some misunderstanding as to its application, both with respect to paraprofessionals and lawyers. And then secondly, the point that Leah's going at, intellectually, it seemed a little incongruent to apply the standard of informed written consent when it's typically used as an exception to an otherwise prohibition found in the rules if you wanted to apply it at the outset of the representation for paraprofessionals, which would otherwise be authorized pursuant to the regulatory scheme that I assume other subcommittees are working on. So there are a few different components there. I think most of my concerns have been addressed by these conversations. I think it is somewhat semantics, and I don't mean to be overly defensive about it. I'm not going to stop the discussion of the group to proceed. I do think these terms do mean something, and we should take care when we refer to it in that way. However, all of the public protection elements that you're all speaking about can easily be achieved. Of course, I would respectfully request we use a phrase other than informed written consent, depending on the situation. As Greg says, there might be a situation in which the representation has begun and informed written consent can be complied with, as that term is defined within the rules. So I'm a little all over the map in my response, other than to say, I think we're making progress, and much of my concerns based on the conversation I'm hearing thus far have been put at ease.
Right, but to be clear, I do think we have a disagreement on, I mean, I think I could be satisfied figuring out a way to avoid using the term if we think that's important, but I believe we want the defined term because we want to use it as defined.
And if I can address the way that it's written in the family law memo that hasn't been finalized yet, but it does speak to this exception to an otherwise prohibited action, the way that it's written. So this is in the context of violence prevention. And it says, if expert witness testimony will be introduced, paraprofessionals are prohibited from introducing or cross-examining expert witnesses unless the client provides informed consent.
Yeah, that would be applicable use. Without seeing the rest of the rule, that seems how I understand how the rules would apply. I wouldn't object to that.
So if
So I
I'm
would
understanding
suggest-
it, I'm sorry, I didn't mean to interrupt anyone.
I would just say,
Mhm.
I don't see there's any inconsistency, and I would just say, if to address that inconsistency, I think we just rephrase the rule to say paraprofessionals are prohibited from entering into a written contract with a prospective client unless they first receive this informed consent. And I think that should resolve it.
So I was gonna say the same thing. We sort of prohibited with the language, we prohibited this act, and we applied the informed consent rule, and
Right.
Emma said it, yeah.
Okay.
And that's okay?
So I'm.
Well, then that
Well,
raises the
right,
intellectual
I-
part I tried to raise before, is why would you otherwise be prohibited from providing these services you're otherwise authorized to provide unless you give all these other concern. Anyway, you guys could, you can take whatever approach you want. My concern is one of, over regulation, and I'm sensitive to the fact that the Washington program had difficulty getting off the ground. And so, I'm just trying to, my own perspective, just trying to help protect the consumer while also allowing the program to flourish and take hold.
I totally respect that and agree, but I think informed written consent to representation is one of the critical consumer protections. So
Okay.
I think.
And so I just want to be clear because I'm trying to keep us focused on what we want 2 rules, right? Have we agreed to that?
So I do think I might have been misunderstanding. I don't mind if there's 2 rules, but I do think we need a separate writing for informed written consent from the written agreement.
Okay,
and I
so that's
don't
the
mind. I don't mind how many rules we have, but I think informed written consent is separate from a written agreement, a retention agreement. And I think it's good. I think it will protect the paraprofessional to have that a separate writing and protect consumers as well.
Okay, so if I understand your position, Amos, it sounds like you're back to your original position, which is no mandatory disclosures to a consultation. They must get informed written consent to representation, and separately, they need to have a written agreement to representation as well.
I do not mind if there is an additional rule added, which is being proposed now as new 1.4.2 for an initial notice to consumers or initial disclosures. I think that's an additional consumer protection that's being suggested, which I think I would not oppose at all. But I don't think that takes a place of providing prospective clients sufficient information to provide an informed decision after consultation and confirming that in writing.
So Greg, maybe
I'm really, yes.
move off of the 2 versus 3, because I think that this group just may not agree. And so there doesn't need to be consensus. And I think that what Kim's proposing, right, is the quote unquote informed consent is embedded in the written agreement.
Right.
So if we just focus on the substance of what should be disclosed and then what should be in the written agreement, and then it could be, the option is it's 2 forms or 3 forms.
Okay.
Okay, I just have a question on the mandatory disclosures. Are we thinking this could be a state bar form that every paraprofessional had to provide or read? Are we thinking that it
would be helpful. I mean, just like judicial council forms are really helpful.
Mhm.
Each paraprofessional doesn't have to reinvent the wheel. They could, if they want to, it could be an optional form, but the rule will say they have to make these disclosures at the first step, whatever language you want to use, and then provide them an optional form to use. They can just read off of it, or in the child support collection rules, there's rules for advertisements and everything, and I know we have that too, right? Somewhere for these disclosures to be in every advertisement.
Yeah, I don't want to take us off track. I just think if we were going to have a mandatory state bar form, I think the rule would simply say you have to use the form and you have to either read it or provide it. The exceptions, I guess, would be if it's not available in the language of the client and you speak the language, something like that. But then that's all the rule would say, right? And then it would be on the state bar to develop the disclosure, the content. That's just a question, Greg, I guess.
Well, I think the content should be in the rule.
Even if the state bar does the form. Okay.
Yeah.
All right.
That's how what we do for mandatory disclosures of lack of professional liability insurance. We provide the language in the rule. So, and then provide the form. I mean, we can then provide the form. Okay, that's fine. So let's, for those of you that are in agreement that there should be mandatory disclosures prior to consultation, is there any suggested language changes that you have to this rule that we want to incorporate now?
I think if we want it to be exhaustive of or all inclusive of what some of the things we've heard, we'd have to talk about be explicit in 4 about you may be in a right to counsel jurisdiction with respect to a housing matter, we're saying there might be other free legal services from a legal aid organization if you qualify, which does cover it. But I feel like the working group would prefer something more explicit around you might be in a right to counsel county or city. So that's one thing that comes to mind.
Honestly, this can't, I just, in my opinion, this can't be the initial disclosure. It's too long.
Yeah, I think I agree that you're trying, that tries to combine, you know, the informed consent discussion with these initial form disclosures. And I think they're just two different things.
So what I was thinking is we could maybe brainstorm on what we think from a policy level is most important things we want the client to know about the person they're calling. You know, number one, they're not an attorney. They have a limited license. That's on the top of my list.
And that's on the top of this list.
Right. Like that's, and maybe not even, did you say, so the paraprofessional, if we don't come up with a mandatory form, the paraprofessional can paraphrase, right? Like as long as it contains all this information, or do we want them verbatim to say this? Because there's, like I said, I keep referring back to the child support collectors because there's some verbatim that language that they have in there. How far are we going to get with this, just the initial one?
You know, that I think that question highlights my concern here, which is I'm afraid we're going to put all our eggs in this basket and really undermine the consumer protection of, you know, having enough information to provide an informed decision later. Can we start with what I think is a more significant one? I very much appreciate the desire to add sort of an initial notice to consumers and initial protections up front, but I very much am afraid that this is going to undermine what we've worked, you know, months and months on and had lots of discussions about, which is sort of the meaty disclosures like Leah is suggesting. You know, we need to have specific disclosures about alternatives and risks after there's a consultation. And I'm just afraid we're confusing apples and oranges and maybe undermining the consumer protection, when I think what you're trying to do is add a consumer protection.
Okay, this is your rule right here. So tell me what to take out and put in.
So I like this rule. I think this is what we've been working with for several months. I think we were saying we need to be a little bit more specific about the risks and the alternatives, and the more specific we can get, the better. And the more we could create a form, a fill-in form, the better. And I really like those ideas and where we were headed with those ideas.
Okay, so start listing the risks that I can put in here.
And this is Kim, that's where I'm coming from. Again, at the point where it's your first meeting with this person, I don't know what risks you're gonna really be able to put in there at that point.
Right, so we switched, well, I don't know, did we switch from the initial, can we call it, you know, notice to consumers or prior to consultation? So we don't keep getting confused between sort of.
My understanding was you were saying you don't want to have that rule, that you wanted to move beyond disclosures prior to consultation. And now you want to go back to the original rule of obtaining informed consent to representation after they've been able to gather information and provide disclosure of relevant circumstances and actual and potential risks, which is really based on the definition of informed consent.
Exactly,
So,
the risks and alternatives. So just so we don't keep talking past each other, and sorry, I think that there's some confusion on because of how I'm explaining it. I'm not, when I say I want to do the other one first, I'm not saying I disagree with having initial disclosures. I just want to not discuss that first, because I think if we're assuming that's all the disclosures there are and we're putting all of them in there, I think the most important disclosures is providing the consumer sufficient information so that they can make an informed decision. And that means disclosing specific risks and alternatives. And I don't think that can be done at the initial stage before consultation. So I'd like to start. Right, I'd like to start with this. I'm not saying I don't agree that there should be another rule or another disclosure. I'm saying this is, I think, where we should focus our efforts.
Okay, I'm ready to focus our efforts. So can we start identifying the risks that you think need to be disclosed, provided to the prospective client before they provide informed written consent to representation?
Yeah,
Because
I
right
think
now we just have risks of agreeing to obtain legal services from a licensed paraprofessional in a language that the client can understand. So now I think we need to actually specifically identify what categories of risks are we talking about.
so. For me, the main one I think is already in 4. So I don't know if we want to combine that or keep that separate. But the potential need to hire a lawyer if services go beyond the limited license. I think that's one of the major risks. I think we should discuss. I reviewed the legal services letter that was sent in advance of this meeting, both the May 14th and the May 19th, and they had some in there. One of the disclosures, I think it might have been focused specifically for housing and consumer debt, but that there may be some, federal claims that they would not be able to, and again, it might be, I don't know how to say this, but they said, I'm reading from the Legal Services May 14th letter, paraprofessionals should also have to disclose that they are not able to litigate in federal court. This is particularly important for housing and consumer matters where federal law claims are common and awfully vitally important. Talk a little bit more, the client would, they think the client would have to effectively waive the federal claims. I don't know if that's true, but that's one of the risks, I think, is they wouldn't be able to bring or litigate federal claims. Again, it might need to be more specific than that because there might be some specific claims that the paraprofessional identifies that they can't help with.
That almost sounds like the potential need to hire a lawyer as well, but okay. Not authorized to litigate in federal court, and the client may have federal claims. Or let's put it the other way. Client.
Can I just ask a question real quick? Would these risks be something that is for every case that would come before a paraprofessional? The ones that we're listing here?
So my opinion, I don't know that we've decided that, but my opinion is when you're providing information to make an informed decision, you provide the relevant facts. And if there are some that aren't relevant, if there aren't any federal claims, you don't need to talk about that. But, if we decide we want to try to standardize this as much as possible, I think there's, some benefit to being simple and providing forms. But this is not intended to be a form. This is intended to be a discussion about risks and alternatives to be able to make an informed decision.
Right, and what we also need to give the paraprofessional some guidance as to what we would consider to be a risk of hiring a paraprofessional.
Correct. But for Kim's question, I don't know that in every case they would have to say, oh, we can't do federal court. If there's no potential federal claims, I don't know that that's relevant.
That's why I wrote including but not limited to.
Okay.
I mean, there may be situations where a paraprofessional can't identify that they have a federal claim. So,
exactly.
But they do have a federal claim. So
Yes.
You may want them to make this disclosure that, look, you may have federal claims and I can't litigate in federal court. So
fair enough.
Any other risks that we want to identify?
I mean, alternatives, I have a lot to say about that, I think, but I think for risks, what about the practice areas where, certain, like they can't do trials or things like that? Does that need to a little bit more of a specific disclosure?
Don't we have that in another
I'll
section?
fall into this potential need to hire a lawyer, in my mind, but
I think we also had that in another section, didn't we, Greg, where it said like, this is the scope of what you can do. I think, well, maybe that's in the written agreement. I think that's what it is.
Yeah, that's right.
But that's a
That's
very
right.
good point. That's a very good point. Because again, I think fundamentally from a policy, before we get down to language, I think it needs to be clear what they can and can't do. That's in order for somebody to decide, yes, I want to hire you, I think it needs to be clear what they can and can't do.
Isn't the list of what they can't do a lot longer than the list of what they can do? I mean, just being facetious here for a point, like they can't perform heart surgery. I'm gonna list that too. I mean, it just seems to me like this list is gonna be so long. Why don't we just stick with, just keep it simple, understandable? It's just already starting to sound
I
onerous.
totally agree. It's
Sorry.
only the stuff
I
that
love
would be.
consumer protection, but I just, again, I wanna,
I
But-
totally agree with your point.
Simple.
I don't think it should include totally irrelevant information like they can't do heart surgery because that wouldn't be relevant. It's just the information that would be relevant to somebody making the decision.
for sure, but let's take a look at the areas they're licensed in and see how many, I think we were talking about housing, right? Did that comment come from housing?
For federal claims, I think it was housing or consumer debt.
Right, so doesn't have a place in a family law contract, for example.
So when you say keep it simple, I'm really struggling to understand what exactly you need here. So to me, including reasonable disclosures of of available alternatives and leaving it just like that is not simple. You're putting
No, that's
all
incomplete,
on the
no, for
paraprofessional
sure.
to keep a running list of all the reasonable alternatives to their services. So that's not simple. What would be
So-
simple is to tell them
Right.
what needs to be in this informed consent, or at least what areas based on the relevant circumstances needs to be in the informed consent. So I'm really putting you all in the driver's seat at this point. I really want you to actually come up with the language because I'm a bit confused still as to what exactly you want this rule to say.
But, okay, let's talk about, really be honest and say, what are we talking about when we're talking available alternative choices? We're talking about attorneys, right? We're talking about legal services agencies who have staff attorneys, free assistance, low-cost assistance by attorneys. We're just talking about, are we talking about something different here? Or are we just trying to get this person to understand that you have these other options that may get you an attorney, either free or low cost?
I don't know.
What
I
if you
think
don't
self-help-
qualify for those services?
Right,
No, but
exactly.
I think there might be self-help or there might be self-representation or there might be LDAs or, I mean, again, I'm not saying we list all these. I'm just saying I don't know that we should assume that anyone who doesn't hire a paraprofessional would hire an attorney.
But self-help is different because we don't represent people. So we're talking about representation here. You know, it's, I don't know, you may be able to represent yourself because your issue is really simple. You know, again, how,
Yeah. That's again, a very good point. From my perspective, I think the more efficient way to think about this and to come up with this list, because I agree with Greg, we should give some direction here, is put yourself in the potential client's shoes. What information would you need to make an informed decision? Or put yourself in the paraprofessional shoes. What information would you need to provide to allow them to make an informed decision? That's the list we're coming up with. And specifically, as Andrew would point us to, the definition, I think, of informed consent. Actually, I think it's either of the two rules. I think rule 1.4b also requires that the paraprofessional explain the matter to the extent reasonably necessary to permit the client to make an informed decision. Same idea. Let's give the paraprofessional help. What are we expecting them to inform a prospective client about, related to the risks of entering the engagement and related to the alternatives?
The problem with those analogies is they are left to the particular circumstances in which they're going to be applied. So 1.4b isn't the matter you're coming to represent me with necessarily. 1.4 kicks in after the representation has begun, and there might be decisions along the way. And so the matter is, you know, whether or not we should object to this discovery request, or we should, you know, settle the case, whatever it might be under 1.4. And then 1.0.1 is the relevant circumstances and reasonably foreseeable adverse consequences to the decision. And again, those change depending on the representation. And here we're getting specific and we're going to say all these disclosures are going to apply in every case, even when it might not be applicable. And so
No, I'm
I
actually
think it's a
trying to follow.
challenge.
I'm actually trying to follow what your instructions are, Andrew. I'm not
Oh,
arguing with you. I'm agreeing with you to say let's change the frame of how we're discussing it, because I don't want to be in an argument. I want us all to be brainstorming to help the paraprofessional, to help the client. What information do we think is relevant to inform the prospective client about, so they can make an informed decision? I'm trying to avoid, we're getting into sort of an argument. No, we should have a consumer protection. No, we shouldn't. We should be more specific. We shouldn't. I want to avoid those arguments. Let's get to where we agree, which
so
is
number one, I think, is a non-controversial agreement. Everyone on the call definitely agrees with that, right?
yes.
Number two, I think it's outside the scope of this rule, but I think where this emanates from is the lack of malpractice insurance. If there was any other, if the paraprofessional didn't purchase their bond, which I guess, I don't mean to sidetrack the conversation, but maybe they wouldn't be qualified to provide the services absent the purchase of the bonds. That's not the best example, but those type of things, those are factual client protective statements that are going to be true in each and every instance. Those are the few, I can think of, but I'm not, again, I still have my disagreement as to whether or not that's informed written consent, but I would encourage the working group or the subcommittee to think about those type of factual level disclosures that you would want the client to acknowledge before being represented by the paraprofessional.
Okay, so sorry, that didn't go as I intended. So you're, again, going
Sorry.
back to factual disclosures as a.
Yeah, like number one, I mean, for me.
Hold on a second, Andrew.
Sorry.
Let me just respond, because I think maybe intentionally, but maybe unintentionally, going back to explaining what mandatory disclosures are as opposed to informed consent. And I'm trying to focus you on informed consent. So we're just talking in a bit of a circle. So what I'm asking you is, let's just say we're trying to come up with a rule to inform a decision, so that to inform a decision maker so they can make an informed choice. Yes, there might be some factual disclosures. We all agree. But there might be some things specific to the circumstances, like risks and alternatives. And that's what we're trying to come up with a list. What types of risks and alternatives should we enumerate here that would inform the choice?
This is Kim. Amos, maybe if I explain maybe why I'm having trouble here, that would help. Because I'm trying not to be, I'm trying to think of ideas, but here's where I'm coming from. And maybe it's because I've, been that regulator for so long. I know why Andrew keeps saying factual, statements. Because if we come up with some list, and then to take action against an individual when maybe there was something they should have thought of that they told them that they missed. And you have to put yourself in order to take discipline against an individual, you have to be in that spot where you know exactly what they should have said. And if we're going to make a rule, I'm just concerned we're putting a rule that we're not going to be able to enforce, because we're never going to be able to list everything. And it's never going to be able to have something that the individual will be able to, we'll never be able to fight it when we try to take discipline against that individual. That's where I'm coming from. And that's why I'm having trouble putting risks in here, knowing that we're never going to be able to get everything and then being able to take action. So I just wanted to explain why I'm struggling.
I agree with you, Kim, and I hazard to guess the court would agree with you too. To the extent that we're going to require them to tailor a list of alternatives and tailor a list of risks based on the client and try to use that as a disciplinary rule, it's either going to be difficult to enforce or it's going to be enforced in an arbitrary way. And so I just do not see the court signing up for this kind of a rule. I think the disclosure should be factual, that apply in all situations, at least under the licensure. And if we are asking them to provide informed written consent or obtain informed written consent, it needs to be specifically, they need to be specifically told what categories of disclosures they need to tailor in order to obtain informed written consent. So for instance, a reasonable, the existence of any financial arrangements, such as referral fees. That's very clear, and it's not going to be difficult for the paraprofessional to accomplish that. But to require them to tailor a reasonable disclosure of all the alternatives to employing that paraprofessional, it's just not a standard that's going to be enforceable, or again, or it will be enforced in a very arbitrary way. And I just don't see the court approving that.
I agree. I agree. So that's why I thought we were going through this exercise, so we could provide some, if we just say alternatives and we just say risks, we're not providing enough instructions and help to make it effective or enforceable. So I thought that's why we were going through this exercise. And again, I'm just trying to help the discussion, because we seem to be at more of a battle over whether or not there should be 2 rules or 3 rules, or whether there should be, you should use the term informed consent. I'm trying to move beyond that to be productive, because I do think we need to provide more information on the risks and alternatives that we're requiring be included.
Well, one way,
I think there's
instead of
different.
saying, I'm sorry.
Yeah, go ahead,
Instead
Greg.
of saying under A2, a reasonable disclosure of the possibility that there may be available alternative choices, including, I would say, a reasonable a disclosure that, I would just call it disclosure, because reasonable disclosure that there may be that that a lawyer, that the client may engage a lawyer as an alternative, or that there may or may be able to obtain a free consultation, really telling them exactly what they need to disclose. And again, that sounds like a it's a disclosure. It's something that actually could go on a form, but to the extent we're asking them to tailor something around alternatives, we need to actually come up with a list of alternatives that will work in every county and apply to every prospective client, which it's going to be very difficult to do.
So to that end, I think there's 3 categories that apply in every county. Private attorneys, and the state bar has a list of lawyer referral services in every county. So that could be a source of, referral just to the state bar website. Self-help centers, the Judicial Council has an updated list on their website. And then legal services agencies, which take care of the free resources for the most part, right? I can't think off the top of my head a joint website, but perhaps there is one. Those are the 3 categories that I think will apply in every case.
And that's exactly, I think those are great. Those 3 are really good. If they're always there, there are also other alternatives that are available to them.
I'm so sorry you got cut out. I couldn't hear most of what you said. Could you repeat that, Kim?
Sorry, I might be having trouble in my location. But I was saying, I agree with you. I think that's tangential, and I think it's something that can be listed in the law or the rule.
Yeah, we're all in agreement. I think that's great. Can I add something to that for the legal services? So I'm going back to the May 14th letter we received from several different legal services organizations. And I think this has been a constant thing we've heard over and over about a major objection to this entire program, which is there may be people who are eligible for free legal services, and that is something that is a relevant piece of information to consumers, that if they qualify for free legal services, and those legal services may be available to them. I'll just read from page 5 of this letter, which says, all paraprofessionals should be required to make written and verbal disclosures in the primary language of the client that they are not an attorney. They should also be required to disclose that there may be free resources that are available to low-income individuals and provide accurate contact information for those services, including legal services, self-help centers, and other online resources. I think the major issue is there may be somebody who is eligible for a free attorney, and they would be better off if they knew that, getting a free attorney instead of paying for a paraprofessional. And I think that is something that should be included.
Okay.
I agree. It's just going to be, I don't think paraprofessionals should be required to provide a list of
No.
potential agencies in the venue of the case, right? Because we're going by venue, right? So, but is there a statewide sort of legal services clearinghouse? I can certainly ask our justice partners and find out, unless somebody on this call knows.
But again, I think the point here is that if they know now that it is somebody who's low income that does qualify for a free attorney, that they should be informed of that. Or more generally, if you're a low income, you may be entitled to a free attorney. I'm okay with trying to generalize it, but I think it needs to be more than just a list. There's a website out there of legal services agencies.
Well, I don't know, the paraprofessional, even if they know that they're low income, that they could say that they're going to qualify necessarily.
Yeah, and in different counties, there's different capacity. There's capacity, there's rural issues, there's lots of issues. So yeah, they're not going to be able to make the income decision or the intake decision for the legal services, but they need to. I think the point is this is irrelevant. If somebody is potentially eligible for a free attorney, that's a relevant piece of information.
I agree. I think I agree. If the paraprofessional finds out that the person is on welfare, for example, they should generally know that there are free legal services agencies that will take on such persons whose only income, either very low income or whose only income is aid. But I think it's too onerous to require them to know all the qualifications and say you will qualify for this agency particularly. Some paraprofessional I think it's a great practice, to best practice to have a list of agencies in your area or in the areas you practice and in venues you practice. That's just, something good you have to do, but I'm not sure if I want to require them to have those specifics, but I am totally for a sort of a general obligation to inform the client that they may qualify for free services.
And if they don't, they should lose their license for it.
I think this is discipline rules.
Yeah, this is discipline. So, I
So they
mean,
won't lose their license.
we have to avoid trying to incorporate best practices in a disciplinary rule.
Some of the bad actors, I can give you an example. This paraprofessional who was, brought up on charges and I think even did some jail time. But anyway, she would charge people to fill out their forms to apply for welfare. This is a while ago.
Yeah, we heard this in housing subcommittee. We heard a very strong opinion that people receiving subsidized housing, Section 8 or similar, almost always have free attorneys available to them. I don't know if that's true, but that
is not true in our county. I wish. There's legal services agencies that try to do that, but we see a lot of people that come here because those legal services agencies cannot help them.
Yeah, I think the housing committee got close to excluding it from the program on that basis, and we didn't, which I think is a good thing. But I think it's another example, similar to your welfare example, that there may be situations like when somebody's has Section 8 subsidized housing, when there's a very high likelihood in some jurisdictions that a free attorney is available to them.
So I'm just mindful of time. We've been going for an hour and 20 minutes now on these three rules. We had allotted 45 minutes. because we've talked about a lot of these things. So I think what we need to do is, I'm going to make a suggestion that we table these rules again, and that you as subcommittee members actually draft some rules that you think can meet the approval of your fellow subcommittee members. And we take these 3 rules or 2 rules. I'm still confused as to where we end up on that, but we take these 2 or 3 rules, and perhaps all 3 of you come back with a different set of rules, and we try to hash it out again at the next meeting, and we move on to the next rule on our list, because we have a long list to go. And I'm afraid we're burning through our time trying to brainstorm right now. I think one of the things that we can do, and this was very helpful during the Rules Revision Commission, is that we can communicate, as long as it's not a serial meeting, you can provide your draft rules to staff. Staff will distribute that out to the fellow subcommittee members, and then each subcommittee member can provide comments and additional changes or suggestions back to staff, and that can be disseminated out. So a lot of this work can happen in between meetings, so that when we come back to a meeting, we're not spending a lot of time, restarting this whole process again, because this is a very difficult area, and it seems like we have different opinions. The subcommittee members have different opinions as to what should be, what should not be in these rules. And I feel like this has become such a morass for us, this topic. And I want to make sure that we're not neglecting the other issues that we need to deal with.
That sounds good to me, and I'm happy to work on it between meetings. Do you mind sending us whatever the most current, maybe what we had before and most current?
Sure. Kim, do you want to, well, I'll leave it up to Kim how she wants to deal with her suggested rules. I can send you, would you like me to send out this particular rule that we've been working on right now, 1.4.2? Because I haven't touched 1.4. Well, I had sent out 3 suggested rules separately, including the mandatory disclosure rules, which are right here. This is Kim's suggested changes. And then this was the original one that I sent to you all, I think over a week and a half ago. I'll just send you everything that I have, and then you can take that and perhaps start working on drafts that you want to send back to staff, and then we can disseminate them out, and hopefully next time we can come to some consensus on what these rules should say.
And
So
I want to
that's-
just ask you to send it to Leah. You
Mhm.
can copy me on it, but Leah is taking the lead on this particular subcommittee.
Okay.
Can I just ask for clarification so we are most efficient? You have been making these edits on the separate document that starts for discussion purposes, right? Not in the full draft rules that you circulated? Is that right?
No, I had to make them on the full drafts rules that we circulated, because the rule that you wanted to return to, which was the original informed consent rule, is not captured in either in these 3.
Oh, got it. I'm just trying to figure out what we should redline against. If we're coming up with ideas, what should the base document for everyone be?
I think that I'll provide you the versions that have been looked at here, and then I think each of you can take an opportunity to draft a new rule based on any one or all components of any particular rule, and then we can go from there.
Okay.
That makes sense.
And Greg, I don't have a problem with you sharing mine. I'll probably be working on it too, but
Okay.
I don't have a problem.
Okay, thanks, Kim. Okay, let's go back to our work plan real quick so we can see where we are. So we are here. We were going to talk about 1.8.1 and 1.8.9. 1.8.3 was on our on for today, but I moved it down to June 3rd because we needed to talk about comments, and I had thought that Leah wanted to revisit the contingency fee caps, but we ended up not talking about that yet. So let's go to the issues on 1.8.1. So this is the business transactions with a client and pecuniary interest adverse to a client. Since I think the last time we talked about this rule, the consensus of the group, although I don't think we actually reached a consensus, was that paraprofessionals should not engage in any business transactions with clients or obtain any pecuniary interest adverse to clients. Professor Moore, and I think Randy as well, and maybe Randy, you can speak to this. There's some concern that a very common practice, at least for lawyers, is to have a lien on a particular matter to secure fees. And again, the purpose of this rule is to protect the client. Whenever a lawyer engages in or enters into a business transaction with a client, they need to comply with this rule, which is the transaction, the terms need to be fair and reasonable, and that they are that the lawyer's role in the transaction or acquisition of the pecuniary interest is fully disclosed, transmitted in writing in a way that in a manner that the client can reasonably understand. The client is either represented by an independent lawyer of their choice or advised in writing to seek legal advice from an independent lawyer and is given a reasonable opportunity to do so. And that thereafter they provide their informed written consent to the terms of the transaction and the lawyer's role in it. Again, this rule what really came out of the fact that lawyers were engaging in entering into business transactions with clients and not doing these types of things, and clients were being harmed. So we promulgated this rule to protect clients. They need to meet all of these requirements or else they may be subject to discipline. And Randy, do you want to talk at all about the liens issue?
Yeah, so the rule as it's evolved in California for lawyers and clients, it stems originally from the concept of fiduciary beneficiary self-dealing transactions used to be in the civil code, exists still in the probate code, and the idea is that any sort of transaction or adverse financial interest between a fiduciary and a beneficiary is burdened by a presumption of undue influence, that somehow the trust reposed by the client beneficiary in the fiduciary could lead that person to enter into a transaction or grant some sort of adverse financial interest without eyes wide open. And so this rule actually works to assure that even if there are what would be very well-meaning or maybe extremely beneficial to the client, the beneficiary, and very altruistic on the part of the fiduciary transactions, say lending money to a beneficiary, to a client, that those things are nevertheless addressed by these protocols that, again, are intended to dispel the presumption of undue influence between the fiduciary and the beneficiary, between the lawyer and the client. And so if you didn't want to have this rule, I don't think you just omit it from the RPCs. I think what you do is you would institute what would be essentially an absolute ban. If that's the direction that you think this should go for public protection purposes. The downside of that is that there might be transactions, things that could be adverse interests, that could be helpful to the client, that would be precluded because you would have no way of eliminating that presumption of undue influence because it was now subject to a complete ban. So that's sort of my sort of overview of why this rule might be helpful. I don't think it's as significant for paraprofessionals as it is for lawyers when it comes to the security for fees. It used to be that the case law was, you'd have to acquire something enforceable through non-judicial foreclosure in order for it to qualify as an actual adverse interest, like a note of deed of trust or a confession of judgment or something along those lines. But cases have held that even a mere lien would be categorized as an adverse pecuniary interest. And so, some of that comes into play here, but those types of security for fees situations are, I think, primarily for lawyers where the fees are much bigger and the lawyers looking to protect their interests and compensation, perhaps different from what you would encounter in the normal fee arrangement with a paraprofessional. I don't know. I hope that helps.
It's very helpful because I mean, I think I still like the absolute prohibition, but besides the lien for fees, can you think of other examples that we might want to consider, allowing this rule instead of having a prohibition?
Well, it could apply to other instances as well when you are in a, you want to say attorney-client relationship, but you want to say a paraprofessional client relationship. And while you're representing that client, you are going to undertake some other business transaction or adverse pecuniary interest that's outside the scope of the representation, but you are currently representing that person and you are their fiduciary, and this rule would kick in.
No, I understand. I understand theoretically, and that's why I think we were leaning towards a prohibition. But I think the discussion last time, or maybe this time as well, is, well, there might be circumstances like a lien for fees. Do we want to allow that? Because this would prohibit even that. But are there other things that we might unintentionally, assuming we generally want to prohibit adverse relationships?
One that comes to mind is the area of non-legal services or dual occupation. And so let's say you have a paraprofessional who's licensed to provide certain family law tasks, and the client is also in need of, say, counseling or family mediation type activities, and the person actually has skills or licenses in those areas. Because they have the hat on as paraprofessional, and the person to whom those other services would be rendered would have the hat on as client or beneficiary, as Andrew said, that would be the typical fiduciary beneficiary transaction, that you would want to go through this protocol to make sure that the client is utilizing their mediation services with eyes wide open, and not because they've reposed undue trust in this person. If it's an absolute ban, then that would be, I can't provide you with these other services because I'm entering into a transaction in which I financially benefit. It's strictly prohibited.
So can I ask?
I was trying to articulate, obviously unclearly, that there might be instances in which it is beneficial to the client to enter into these transactions or business arrangements with a paraprofessional. It's not always a negative, a detriment to the client. But should you enter into any of those type of arrangements, you want to make sure that they comply with these protocols. If you were to ban it, then you're precluding that opportunity altogether.
Can I ask just a follow-up question as an example? If there's a paraprofessional that, in addition to providing paraprofessional services, also is a notary and also helps fill out forms, but not providing legal advice, so it's not a paraprofessional task, are you saying that that would be an adverse interest if they entered into a contract to do non-legal services?
No, I think what they're saying is this rule covers not just pecuniary interest adverse to the client, but also any business transaction with the client. So
Yeah, it's the idea that the client, because of their relationship with the legal services provider, has reposed a higher degree of trust, and all of a sudden the paraprofessional is pitching other services or other products or any other type of transaction, and you want the client protected.
So I'm convinced to include this then, because I do think, I want to avoid adverse interest, but I do think we want to encourage, if there's other services that they provide that just happen to not be legal services, why not allow them to provide those services with the protections?
I agree. I also think, for example, in family law, Section 2033 liens could be used, should be used by paraprofessionals as well. The family law real property lien. So if we have a provision, paraprofessionals can't use that to collect their fees, yeah? So I want to make sure we provide access to that tool for them as well.
Greg, we'll try not to change our mind on all of these.
That's okay.
I thought we were going to include that from the very beginning. We liked it.
Oh, my understanding was we landed on no, an absolute ban.
Yeah, I think
Really?
so.
Okay, it's been a while. There'll be many meetings.
Yeah, it's been a while. Kim, do you have any feedback on this rule? Are you in agreement to include it as written?
Yeah, if it's something that's beneficial to them, I think that it should be included, but we want to make sure that we have the safety net around it.
Right. Okay.
So I'm good.
All
Yeah.
right.
At first I was going to join the band one too, because I was like, oh, I hate to start going into that area, but if it is beneficial and there's use for it, I agree.
Right. Okay. All right. Next on our list, that was, I like that we moved so quickly through that one. Was I think 1.8.9. This also I think should be rather quick because we did talk about this rule. Kim, you weren't there, but this is a very specific rule. It's very unique to California that we have a rule like this. But essentially, this covers a very specific situation in which a licensed paraprofessional purchases property at a probate, foreclosure, receiver, trustees, or judicial sale in an action or proceeding in which they or their firm are affiliated by reason of a personal, business, or professional relationship, and is acting in a professional capacity representing a party or as an executor, receiver, trustee, administrator, guardian, or conservator. Professor Moore's comment, I think, on this is essentially to the extent that paraprofessionals are not going to be authorized to act as a representative for a party in this type of action. Do we need this rule? And I think the response to that probably is no, for that portion of the rule that envisions that. But we can imagine a situation in which a paraprofessional may be acting as an executor, receiver, trustee, administrator, guardian, or conservator. That could happen because it has nothing to do with the scope of their licensure. And to the extent that is true, we might want to tailor this rule so that it's clear that when they're acting in that capacity, they cannot directly or indirectly purchase property that is subject to this kind of a proceeding. So essentially what that would require us to do for this rule, let's see, or is acting as, we would take out this part and you would just say acting as a, shoot, it's not tracking changes. Let me track. What is tracking? What? Huh. I have track changes on and it doesn't seem to want to track them. But essentially you would just take out this portion of the rule up until it says as an executor. And so it's an absolute ban. And then it also says you shall not represent a seller at a probate, foreclosure, receiver, trustee, or judicial sale in which the purchaser is a spouse. And again, I don't think this provision is necessary because at least as far as we are defining the scope of permissible practice for paraprofessionals, that they might not be representing a seller at any of these proceedings. But please correct me if I'm wrong, because I may not be up to date on where the housing group is on that.
I think
one
that's
last
right,
thing I'll say about provision C is we had to add this in because there is a probate code section that permits and Randy, you might have to help me out here, but that permits a lawyer to purchase a property. So this is almost an exception to this rule as long as they comply with the requirements under the probate code, which essentially means that there's a judicial officer overseeing the sale to the lawyer. So because there is a judicial officer, the trial court is essentially overseeing and making sure that there's not overreaching going on by the attorney. They would not be in violation of this rule if they comply with those probate code sections. So in short, I think we still need this rule because I can envision that a paraprofessional will, in some circumstances, be acting as an executor, receiver, trustee, administrator, guardian, or conservator, and you would want to probably have an absolute ban if they're acting in that type of fiduciary capacity. Randy and Andrew, do you have anything to add on this?
It's grabbing my rule book.
Sorry.
No, I think you've covered it. There is that aspect where the prior rule did not match with the permissibility that exists under the statute. And so that was the biggest change that the Rules Revision Commission had to get, was to harmonize this rule with the statutory scheme.
Mm-hmm. Oh, one thing I should point out, it does carve out this exception if you comply with the probate code, but the paraprofessional would still have to make sure the transaction is subject to Rule 1.8.1, which I think just talked about, meaning business transaction. So you'd have to comply with the client protective aspects of that rule. And then also 1.7, which is the conflict of interest involving current clients rule. So they'd still have to go through the conflict analysis to make sure that they could do it, even if they comply with the probate code. But I'm now wondering if the probate code is written in, I'm going to pull it up here, but to allow, if that's just an exception for attorneys in the matter.
Yes, so if you go to 9884 of the probate code, this chapter does not prohibit the purchase of property of the estate by the personal representative or the personal representative's attorney.
Right, okay.
I guess if we wanted this policy to be carried through completely, there would be conforming amendments to the exception in the probate code to encompass the activities of a paraprofessional.
And that's also defined in 9880. It says, except provided in this chapter, neither the personal representative nor the personal representative's attorney may do any of the following. And that's what the next four provisions are intended to apply to.
So to the extent that we would continue to carry a paragraph C, it would really be in the paraprofessional's capacity as a personal representative, i.e. an executive receiver, trustee, etc.
I think that's right.
Does anyone have any questions about this? So essentially what we're saying is, I think what we're proposing that the group may want to do is keep this rule, which provides an absolute ban in these situations unless you comply with the probate code as well as Rule 1.8.1 and 1.7. But we just need to remove this idea that they would be acting that they would be representing a party in one of these proceedings. Unless, of course, the housing department, the housing subcommittee is envisioning that they would be authorized to, in which case we would want to probably keep that provision in as well, part of the provision.
So did I hear you correctly? Unless the paraprofessional is licensed to provide representation in any of these categories of cases? Well, they are
so,
guardianships and conservatorships.
Right. No. I'm saying this should definitely stay in because anyone can really fulfill those roles.
Okay.
You don't have to be a paraprofessional to fulfill those roles, obviously.
Okay.
Or be designated in those roles. The question is whether or not they would be acting as a lawyer or paraprofessional for a party in this type of a proceeding, an action or proceeding.
Okay.
And
which
my
type of
understanding is that they would not, but I think this is just a situation where we probably want to just mirror and stay informed about what the housing subcommittee is proposing and what the actual working group is recommending. And then this rule will just have conforming changes based on that.
I'm so sorry to be dense here, but I'm just not understanding. When you say this type of a proceeding, are you referring to a sale, the sale proceeding? That's what you keep saying, housing?
A probate, it's written that way to be somewhat generalized in some ways, but it's a proceeding in which there's a sale of property in a probate, foreclosure, receiver, trustee, or judicial resulting in judicial sale.
Okay.
That type of provision. So it's a pretty broad category.
I'm on housing. I don't even remember that we discussed this as a possibility. for representation. So
No.
we have another meeting. coming
No,
up.
I think mostly
With
we're talking
landlord
about
tenant.
unlawful detainer at this point. So
Right?
that's, yeah.
Okay.
And this is just an outright prohibition for 1 and 2, right?
yeah,
That they just can't do it. Yeah, and it's just cleaning up the language to make sure that it's consistent with what actions they're really going to be able to do.
yeah. And I think,
Yeah.
yes, that's correct, Kim. But I also think paragraph B probably should just be removed completely. Because I can't imagine a paraprofessional representing a seller at a probate, foreclosure, receiver, or trustee, or judicial sale in an action.
Mhm.
So at least as far as I understand the scope of the housing licensure at this point. So essentially, if the group's in agreement, what we would do is just remove from acting to this, or this would all come out. I apologize because I don't know why it's not tracking my change. Oh, no, it is. Look at that. Acting as an executor, receiver, that would remain in. And then we would remove B entirely. And this would become B.
Sounds good to me.
Okay.
And just to be clear, there's no chance that that individual will be able to represent based on the housing committee's input, right? Subcommittee's input. B, they won't be able to do that. I just want to make sure that that's absolutely okay. Perfect.
Stay abreast of that because I'm not even sure, as Fariba noted, I'm not even sure the housing subcommittee has contemplated going beyond the unlawful detainer.
It's
So
just-
what's been authorized, what's been authorized in housing is landlord tenant. And then they're looking at what's going to be brought forward at the next meeting is to add lien clearing. So it does not include any of this.
And now it's sticking in my head something about title clearing action.
It's not, but it's actually just, the phrasing has been cleaned up. It's lien clearing.
Okay, got
So
it.
it's not really title clearing. It's not quiet title. It's lien clearing that doesn't involve, it's trying to resolve things before you have to file an action.
Okay.
So that's what it's limited to.
I'm good with it then too.
Okay.
Me too.
All right. Leah, you are back. I just want to get you up to date where we are. So we have decided we're going to, once again, we're going to table the informed consent, mandatory disclosure, and written agreement. And what I've asked each of the subcommittee members to do, and we're going to send them copies of Kim's changes to the 3 rules that I set out for discussion purposes. I'm going to send them the original. I can resend you all the original 3 rules that I put together for discussion purposes. And then I will also send you the latest version, because we started fiddling around with 1.4.2 in the master set of rules. I will send you a copy of that, as well as rule 1.5.2, the written agreement rule from the master set of rules. And what I'm asking each of the subcommittee members to do is, to the extent they can, draft a set of rules, either 2 or 3, that they would like to propose to the rest of the subcommittee members, and send that to staff as soon as they can. And we're going to, I think, hopefully try to have some of the discussion, which will become part of the materials for the next meeting as well, that can be posted. But send email responses to each person's version and to staff, and then that will be disseminated to everyone so that we avoid any sort of serial meeting. So we can actually kind of move the discussion forward a bit between meetings as well, and then take them up again next week.
Sounds good.
Okay. We have 10 minutes. I guess we could actually address that other 1.8 series rule that I had pushed down, so we take advantage of these 10 minutes. So I had pushed down 1.8.3. This is the gifts to clients rule. And I believe Professor Moore had some feedback on that, whether to amend to remove A2 if a paraprofessional may not, this again, I think is in the same vein as what we just discussed in 1.8.9. So let's take a look at that rule. Okay. So A2. So to catch Kim up as well, this rule really limits and puts some ethical restrictions on attorneys when they obtain a gift from a client. So there's an absolute prohibition. They shall not solicit a substantial gift, including a testamentary gift, to the licensed paraprofessional or a person related to them, unless the licensed paraprofessional or other recipient of the gift is related to the client. So you can only do this from family, essentially. And 2 was you cannot prepare on behalf of a client an instrument giving the licensed paraprofessional or person related to them any substantial gift unless the licensed paraprofessional, the other recipient of the gift is related again, or the client has been advised by an independent lawyer who has provided a certificate of independent review that complies with the requirements of this probate code section. I think what we want to do is probably just remove this because and again, if staff or any of the subcommittee members know that I'm wrong, please do speak up. But I don't believe we're contemplating that a paraprofessional would be authorized to prepare an instrument like this that would provide a substantial gift to themselves or anyone related to them. In other words, they can't prepare a
A
will.
will, a trust, or some other testamentary document.
So unless it's
They could a lien.
painfully obvious, the sort of background behind this rule is that, sometimes lawyers in the old model where the lawyer was a generalist would be a longtime provider of legal services to an individual or to an actual whole family, and they would become someone, while not quote unquote related in the family sense, but someone who would be close enough to them that they would receive some sort of substantial gift, maybe even a testamentary gift because of that long-term personal relationship that built up with the individual or with the family over years and years of a variety of, again, generalist legal services, which in my mind doesn't sort of fit the model of the paraprofessional perhaps, but that's where it comes from, that this could happen. And the statutory section, the probate code 21384, even says that where it would normally be prohibited, the lawyer could get another lawyer to basically generate a certificate of independent review to make sure that the testamentary gift was completely fair and reasonable in that setting. And so that's sort of where it is for the lawyers. I'm not sure if that whole background and policy transfers over to paraprofessionals.
I guess I'm not seeing the harm in keeping this one because again, it seems like a prohibition that is clear in the attorney rules, and why not keep the clear prohibition? I guess the assumption is that preparing the instrument is legal services. So if they did it, it would be beyond their license and they could be in trouble for that independent reason, separate from violating this express prohibition, but I'm not sure that's enough of a reason to exclude it. I'm fine if you think it just doesn't apply, so we should just take it out, but it seems like a clear rule that lawyers are prohibited from doing this and paraprofessionals should be prohibited from doing it as well.
Yes, I think the idea was A1 would be included, but A2 excluded.
Exactly. And for the reason you just explained, Amos, to the extent they prepare an instrument and they're not authorized to do that for a client, they're going to be in trouble in other areas of these rules. So
that makes sense.
And if they can't do it, it'll almost be a contradiction to have it in there, right?
Right. It almost, it would be confusing because it might lead them to believe they can't.
If it's
unintentional
under legal
influence.
services, preparing the instrument.
Nothing to do with a lien clearing authorized scope of practice. This wouldn't implicate that at all. Meaning the two that we're striking
Wouldn't implicate
if they're authorized to clear liens, That doesn't mean they're authorized, I guess, to add liens. I'm thinking about if you prepared on behalf of a client a lien on their home to your benefit.
Would that qualify as a substantial gift? I don't think it would qualify as a substantial gift because a lien is usually you're trying to obtain fees for services, and a lien is an instrument that's used to try to secure those fees. So I don't think that would qualify necessarily as a substantial.
Okay. Okay.
I'm sorry, I actually have to jump off a few minutes early. To pick
Yeah,
up
I do
my
too,
kids.
actually. But that was we knocked out 3 rules after all of that, so that's good. That's good. So I will probably get all those versions of the rules out tomorrow, if that's okay.
That's
Okay.
great.
Okay.
Thank you, everyone.
Bye. Thank you.
Thank you. Bye.
Bye bye, everybody.